So I'll tell you a bit about why, how we designed this project and why we designed it the way we did. Hi, how are you? Come on in. That's okay. Come on in, have a seat. And also tell you a little bit about Her Justice. So we're in our 25th year as a nonprofit, and we serve poor women in the city who need help in family law, immigration, divorce cases. We have an interesting model in that most of our cases are represented, most of our clients are represented by lawyers at the major law firms like Kirkland & Ellis and others in the city, which means that we on staff sort of triage cases. Clients call us for help. They meet us at certain walk-in centers in the city, and we figure out if they have a case that we could possibly match with a pro bono attorney. Which means we're experts on the subject areas that, in certain subject areas, and we train pro bono lawyers. So throughout the year, we do lots of trainings. We're going to talk about child support today. So we do child support trainings because the lawyers who are helping our clients have lawyering skills, but not necessarily subject area expertise. We have a huge range in the city because even with a fairly small legal staff, about 17 or so folks in our legal department, because of that model where we're having pro bono lawyers, many of them at the big law firms in the city represent our clients, we're able to help over 3,000 clients per year. And so we see a lot of cases, and we see a lot what's going on in the courts. We work in all 5 boroughs of the city. And we've gotten really interested. I mean, the work that I do as policy attorney at the organization is to think about what are the systemic issues that are coming from our case representation. Do we keep hearing clients complain about this again? And is there something that we can do with policymakers to make a change? Can we talk to the courts? Can we talk to state legislators, city council to change a law? So with all of that insight we have from all of our lawyers sort of out in the field representing many, many clients per year, we have a pretty good vantage point of what's going on. And with child support, we got particularly interested because there are many, about 90,000 filings in New York City family courts per year. So 90,000 people are filing for child support or are involved in a child support case, and none of them, with the small exception, have the right to an attorney if they can't afford one. So there's certain types of cases in New York. Of course, in criminal cases, a defendant has a right to counsel. But in civil cases, people in custody litigations, if they're unable to afford a private attorney, have a right to counsel, but there's no such right in child support cases. So here we are with the capacity to help a lot of people who can't afford attorneys with a very sort of popular type of case, this child support need from the courts. And so for us, it's a pretty good match. It makes sense for us to be doing a lot of those cases. They're also complicated cases, and we'll get into in the ways that they're complicated, but it's our view that they are cases that would be difficult for people who are not familiar with the legal system to do on their own. Not all of these types of cases, but many of them are. And that's where we really put our pro bono attorneys, are on the complicated cases to make a difference in a family's life. And especially in a poor family's life, a family that could be on and off of public benefits without support from the other parent. So this is where we've put a lot of our work in sort of the economic justice for our clients that can come through child support. We represent mostly mothers. We represent all women. All of our clients are women. Most of our clients are mothers. The vast majority are mothers. And in child support proceedings, the people we're representing are mothers. Typically, the person on the other side of the case is a father. I'm going to probably talk in generalized gender language like that we're representing the woman, the mother, but of course the law is gender neutral, and we'll talk about a couple of places where the law is finally catching up to the way families are actually composed. So that's just a note I wanted to make up front. And also one other thing to say before I let Jackie give you some other information. About 80% of our clients are survivors of domestic violence, and in particular, child support is important in those families because having money and having access to resources can make the difference between somebody staying in an abusive relationship and leaving that abusive relationship and thriving with their children. So it's, again, a particular interest for us for that reason. Okay, Jackie, take it away.
So, first of all, just want to thank the Fund for Modern Courts who've been helping us with this project, and I think Denise is going to come soon to talk to us as well. So we'll talk really briefly about why court monitoring for this project. Rachel's already mentioned that we hear from our pro bono attorneys, we hear from clients that they have really significant challenges in family court. They have a lot of trouble representing themselves, and they experience some real access to justice issues. So court monitoring is a chance for us to get into many, many more courtrooms and to get in there not as lawyers, but as much more impartial observers who can fly under the radar a little more. So broadly, court monitoring is an avenue for citizens to be involved in our court system. It provides accountability. As you can imagine, a project like this helps us to understand and get a very clear picture of issues in the courts, and then to use that information and in a project like this, that really robust information from a broad variety of sources to advocate for change. And court monitoring also has a really important public education element, and we're thrilled that you as law students will be in courtrooms. A lot of people study family law. Very few of those really end up in family court understanding how difficult it is for parents to navigate that system beyond everything that you learn about what a custodial can and can't do. So as we go through this training, Rachel's going to be giving you a lot of information about how the child support system works, the law there. We'll also be talking about our court monitoring survey tool. And what you should keep in mind is that when you walk into a courtroom, it can be difficult to understand exactly what is going on. These cases happen very quickly. Many of the cases that I have observed, now other volunteers already in this project, something might be over in 5 or 10 minutes. It might run for half an hour, in which case you'll get a huge amount of information and data for it, something fantastic. But as you go, you are all very smart, you have a great understanding of the law, you'll pick things up, but also don't panic if, as you're going, there are some questions that are very difficult to answer, especially at the beginning. And, we always want to emphasize you don't need a perfect knowledge of the law. You are trying to get the experience of a litigant who will know far less than you usually. So we really encourage you to really back your own understanding and experience and your opinions, because that's why I've asked you to be part of this project, because I think that your opinions will be hugely valuable for us.
And I'll just say that when I was in law school, I don't know if it was an assignment or just on a whim, I spent a day in Brooklyn going to family court in the morning and federal court in the afternoon. And if any of you has ever been if you've not been in federal court, you might want to do that at some point after you do this observation in family court, just to really see the tale of two cities playing out in our court system. The contrast between the two is stark. You'll see small courtrooms in family court, metal detectors, rushing. People no one knows where to go. The signage is poor. All of these things that I think will put you, as Jackie said, in the shoes of the people who are asking the court for help, and to really appreciate how challenging that is. And then you go to federal court, and it's like this room. It's beautiful. The judge is elevated. There's clarity. So it is a really interesting experience that really was formative for me perhaps in my career, I guess. So we're going to talk about, this is it. We're going to talk about child support. Again, as Jackie said, you do not have to be an expert in child support. In fact, court watching is more successful when you're not an expert, because you're really able to put your shoes in your feet in the shoes of somebody who is confronting the system possibly for the first time. But nevertheless, I'm going to give you some basics of child support so that you have a framework for what you're going to be seeing. And there are some questions on our tool, which Jackie will go over with you later, that ask you to respond with substantive information, like what kind of case this is, which we'll get to. So anyway, bear with me. If you have questions, let me know. If I'm too fast, you should also let me know. So New York, child support is something that's done by state. So there are some federal guidelines coming out of the federal office for child support, but by and large, the states have their own child support laws. And in New York State, we call the law that governs the Child Support Standards Act. It's about 25 or even more, almost 30 years old statute, and it sets forth a formula. So in most cases, child support is done with a calculator, literally with a calculator by the court. We're going to talk about where it's not done that way in a moment. And the idea, the premise behind child support is that both parents have an obligation to support their children. So not just the custodial parent, which is the parent with whom the child lives, but the non-custodial parent who doesn't live with them, both have an obligation to support the child. And the courts try, because child support is a fairness statute, right? So they try to not penalize or make up for the fact that the child was living in one home and is now living between two homes, right? And so the finances of that family suffer when you make two homes out of one. And so the courts are trying to sort of remedy that, to fix that situation and get the child to the point of a living standard similar to the one before the family broke up. Now, of course, this is imperfect, but those are the goals of child support. And just so you know, and again, this kind of knowledge is background for you, but child support in New York is an obligation until the child is 21. Some other states, like in the South, a couple of states are 18. New York, it goes to the age of 21. Okay. So many of the cases you will see are initial orders of child support, which means that somebody, the custodial parent, the person who has the child, is suing with a petition, which we'll look at later, for child support for the first time. So I don't know the numbers for us, but we get many callers who want to know, okay, our family is broken up, I'm now the single parent, I need support from the other parent, what do I do? And so that's the boat that we're in at that point. Hi, Denise.
Hi, I apologize.
That's okay. Have a seat. I've launched into the details, the child support details.
Okay.
And then do you want me to introduce you now, or do you want me to...
Whatever you think. Did you do
Here, can you sit here? Because
Yes.
at some point you're going to be on this video over here.
Oh,
Okay.
I didn't.
Yeah, I know. So, do you want to introduce yourself?
Sure. My name is Denise Kronstadt. I apologize for being late. I was at another meeting. And I work for an organization called the Fund for Modern Courts. I'm the deputy director and the director of advocacy and policy. And so we're consulting. We do court monitoring, so we're consulting on this. And at whatever point you tell me it's appropriate, I'll talk about the thematic pieces of court monitoring, but you're already in your
Right.
presentation. So
Okay, great.
thank you. Thank you. I apologize again.
So, again, initial orders of child support. One note here, and you'll see this, we'll refer back to this later, is that some people whose children receive public benefits, welfare, are not able to pursue for child support because by receiving public benefits, they've assigned their right to receive child support from the other parent to the state. I say this because when we talk later and after this presentation about which cases you want to watch in court, and we'll provide guidance, there are some cases where the government, the state of New York, is bringing a case on behalf of a child against the non-custodial parent because that family is receiving public assistance or welfare. We don't want to look at cases where the government is one party in the case, so we will exclude those cases. I just want to put that out there. I'll show you what that looks like, or Jackie will show you what that looks like later. Also, there are many cases in the support parts, which is what we call the courtrooms that handle support, that are spousal support, support from one spouse to another. You may see, and we'll talk about that, a case that involves child support and spousal support. That's fine. We're not going to have you observe cases that are spousal support only. What we're looking really at is child support because it's, as I described earlier, an area that we're quite interested in. So just want to sort of frame us in those terms. So one of the initial threshold matters in a child support case is establishing parentage. Now, I mentioned earlier that the law is trying to catch up to reality, and this is one of those areas. I mean, paternity is a very gendered word, obviously, that really relates to fatherhood. So the traditional requirement is that unless the parties are married when the child was born, or the father signed an acknowledgement of paternity, which is a form from the state saying, I am the father of this child who was born to this mother, to whom I was not married, then you have to seek paternity, an order of paternity, which is called an order of filiation in the family courts. So before the court is going to issue child support, the court wants to ensure that parentage is clear. So there are cases more recently, because of the legalization of same-sex marriage and because of changing definitions in the law to match reality of family composition, that are granting paternity to a mother, to a same-sex mother, a mother in a same-sex couple. So know that this is changing, which is actually a really exciting area of the law. But what you may see is a P docket number, and we'll look at docket numbers later, but that is a paternity case, and it is what the first step is. If I file for child support, I was not married to the father, and the father didn't sign an acknowledgement form, the first step is for me to file a paternity case. And then the court will decide, is the father disputing that he is the biological father of this child? If so, the court may order DNA testing, or may hear argument from both of us about that. If the court, the support magistrate, who is the jurist presiding over support cases, can't resolve the issue, if the two people are disputing paternity, it may go up to a family court judge to decide. The judge decides paternity, and it comes back to the support magistrate. You're going to be watching cases that are in front of support magistrates, just so you know. That's a specialized role that the court has designated for certain jurists, certain judge types, who have expertise in child support matters. So you're going to be watching support magistrates, but just know that you might see two people. He is the father. No, I'm not. I mean, I had a case recently where there were identical twin brothers involved, and my client was saying one of them was the father, and that one was saying no, it was the other one. I mean, it's sort of, you can't make it up. It's like on TV. But there are disputes about paternity as a first matter before you get to what the money is involved in child support. So, okay. Then we get to child support. Now, paternity has been established, or it was never disputed to begin with. Here we are. What is child support? There are three components of child support, and these are the basic obligation, which is the money from one parent to the other, mandatory add-ons, that's what they call them under the law, and we'll talk about those, and discretionary add-ons. Also, the courts will require that one parent provide health insurance to the child. So you might hear the support magistrate saying, does one of you have health insurance through your work? If so, then the child must be covered. If neither one has available health insurance through work, let's say they're both on Medicaid or public health insurance, then the court will typically order the custodial parent, the one who has the children, to make sure the child is on that public health insurance. So these are the basic components, and let's turn to the first component, which is how to crunch the numbers from money. So remember I mentioned before, child support is a formula. Part of the formula is a percentage of parental income per child. So you can see here that for folks who have a lot of children, the percentage doesn't really go up that much as compared to, let's say, for two children. But this is the idea that the court is looking at what is the combined parental income. Child support is all about income. So what is the combined income of the two parents? And the percentage of that is what should be going to the child per year. So if the two parents make $100,000 combined, $17,000 of that should be going to the child per year. Then the question is, who should pay what? So the person who has the child with them most of the time, the custodial parent, doesn't obviously pay for the child. I mean, in life, that person's paying for the child. The non-custodial parent, will pay their portion of that based on how much of the total income they earn. So let me give you an example. I earn $40,000, the father earns $60,000. He earns 60% of our $100,000 combined. He's going to pay 60% for our one child of $17,000 a year. Okay? So again, you don't need to be knowing that to observe these cases, but I want you to have a framework. Like, we're not going to ask you what percentage was applied. It's statutory, it's mandatory for the court to do it like this, but I want you to have a framework for what the court's doing. And sometimes the court, if you see two people who have on the books income, two W-2 earners, She's a paraprofessional, like in the schools, the Department of Education, and he works in the subway system. Those two people have W-2s for their taxes, pay stubs, documented income. The court's going to ask them for those two things and take out a calculator and figure it out. I mean, it truly is that simple, where income is simple, and we'll talk about cases where it's not. Okay, so as I said, you're determining each party's income. The trick really becomes in these cases where income is not that clear. You can see sort of the standard categories of income that are spelled out in the statute, right? As I just said, earnings on a W-2. If you're out of work for an injury, you might be getting workers' compensation or disability benefits. If you're unemployed but were employed, you might be getting benefits there. You might be getting retirement benefits. But even non-recurring, if I win the lottery, if I'm so lucky to win the lottery, guess what? That money will be used for my child support obligation. In the first, we mentioned we're in the initial child support realm, right? Now, I've sued for child support. We're going to court for that. There's not a previous order. Both parties have that obligation to show up with proof. You will see many times that the court is saying to each parent, where's your proof of income? Where are your pay stubs? The letter from your employer? This is often a discussion in the cases. So you will see that. There are deductions from income, just so you're aware. People get a deduction from their income for taxes they pay. If I have another child from a previous relationship and I'm paying child support because that other parent took me to child support court, I get to deduct that from my income. So, right, it's a fairness argument. So if I'm already paying $300 a month for my older child, I'm not going to be, my income is going to be reduced by $300 for this second child. As I mentioned earlier, like if you're close to the poverty line because you're receiving public assistance or supplemental security income, which is a federal government program for poor people, the court is not going to further impoverish you and require you to pay child support. So there is sort of a floor for child support. And because we deal with poor families, we see a lot of that on the other side. Sometimes we take a case, though, because the mom who comes to us doesn't know what dad is earning. Let's say they've been estranged for several years, and without an attorney to help her do discovery and find out what there is, she would have a hard time in court making those arguments. It may end up, well, he's on public assistance. He's receiving welfare. The court's not going to further impoverish him for that reason. But with our help, we can get to that information. So I mentioned this earlier. This is really summed up by what I said in terms of the calculation, so I'm not going to do that again. So here's where it gets tricky, and frankly where a lot of her justice cases are, is where income is not clear, where it is there's not a W-2 or some kind of document that clearly shows the income. And then we really add a lot of value, I think, to our clients' lives. Because we're able to, with talented lawyering from law firms and our own lawyers in-house, we're able to really advocate for the court to dig deeper. And we're able to ourselves sort of dredge up information through the discovery process that helps the court. So one of the concepts that comes in here is imputing income. And the idea there is, let's say dad, again, maybe the non-custodial parent, shows up and says, I'm not working. Well, for child support, since I started by saying there's an obligation for both parents, that's not good enough. There has to be more to the story. And let's say mom knows that dad last year had a job that paid $50,000 a year. So the question is, why does dad not have that job now? So mom may have proof or her own testimony saying when we were together last year, he was earning $50,000 working for the MTA or whatever it is. That's his former income. She can argue through her lawyers that income be imputed or charged to him now. So the court should act as if he's currently earning the $50,000 he used to earn, because guess what? The reason he's not earning $50,000 now is because he messed up on the job and got fired. So he shouldn't be rewarded in this child support proceeding for having lost a job or lost that income. But let's say that dad, especially after the economic crash, we had a lot of families that were really struggling to regain employment. So if dad's able to show, here are my records of how hard I'm looking for a job, I've gone on this interview, I've asked this place, I've looked on this website, that person can kind of overcome the argument, hey, you were making $50,000 last year, now you're not. What's up with that? We've had some really interesting cases where it's not necessarily that dad is reporting no income now, but he owns a business and he says, I earn $10,000 a year. Well, he's also driving a BMW. So we have some financial accounting firms that work with us pro bono who will surveil businesses, stand outside and see how many customers, analyze. We've had a lot of livery or taxi drivers who are not, we don't think, and our clients, most importantly, don't think, are reporting full income. So they'll do an analysis of the ride receipts to really see if that is all they were earning, is what they're telling the court. And so the idea is we're doing this extra investigation to say, you may be saying that you earn $10,000, but in fact, look at this analysis of your lifestyle. You've got a rent of $2,500 a month. How can you be earning $10,000 a year? So this kind of information is what we do in really advocating for a client to get her fair share. Those are really, really interesting cases. And if all else fails, the Family Court Act, which governs child support, provides that the court shall determine child support based on the needs of the child. So if there's zero information or inadequate information that we can mount or present to the court about dad's income or the non-custodial parent's income, then mom, the custodial parent, can say through a financial disclosure affidavit, which is like kind of like an assets, liabilities, expenses sheet that she has to give to the court. Here's what it costs to feed my child, clothe my child, house my child. Here are the basic necessities, and on the basis of that, the court shall order child support. You might see sometimes in these initial orders of child support, if there's a hearing, that the court, let's say dad never shows up. We're going to talk about service in a few minutes, but dad has to be notified if she sues for child support. He has to have notice of the action against him. But sometimes dad doesn't show up. I mean, parenthetically, I will say there's a real lack of public education and awareness around child support. And I think the word on the street is kind of like, don't show up and they can't get support against you, which is not at all true. And it's a shame that people don't participate more. But what happens not infrequently is that the other person, the respondent, dad, let's say, will not show up to court after a few times, and the court ultimately, on mom's information about the needs of the child, the expenses of the child, and her testimony, will determine what is child support. So you might see that happening, sort of a one-sided, just mom there in a hearing, presenting her own evidence. Okay. And then I mentioned, so that's really part one, is like, how do you get to the dollar amount of child support? The next part of it is this mandatory add-ons, and those are dad's, or the non-custodial parent's relative share based on his share of the income pot. As I mentioned in my example, was 60%. So his pro rata, his relative share of work or school-related child care expenses. So let's say mom is working, someone has to care for the 3-year-old at daycare. Dad is supposed to pay his share of that. Or mom is in school full-time and the kid's in daycare. Similarly, dad's supposed to pay for his share. Or out-of-pocket health care expenses. I mean, many of our clients are on Medicaid, public health insurance, and do not have out-of-pocket. So you might see that in the courts, because really you're going to see, I think, mostly poor people in these courts. But if someone has government, or employer-sponsored health insurance, they might have $20 copays, or if the child has a special medical need, therapist costs, etc. Those things are supposed to be shared by the parents in relation to their income amounts. And then the final part is discretionary. Now, discretionary, of course, means that the court can choose to issue an order containing these or not. And these are child care expenses if mom is looking for work. So she'd have to mount a pretty good argument. I'm hitting the pavement, I'm looking for a job, and I'm doing it so many hours a day that I need someone to care for my child. Here's the proof of what I'm paying. Get dad to pay part of it. And then we see this a decent amount, although, it really sort of depends on the demographics of the parties. private school or college. And that's typically ordered where there's a history. Let's say the family has broken up after the children have been in private school for 5 years. If the parents had previously agreed that they were going to share private school tuition, the court may order going forward, Dad, you pay your 60%, Mom, you pay your 40%, whatever it is. I think it's rare in our cases, but you certainly do see it. Camp and after-school expenses, to the extent the attorneys can argue those are like childcare, we see those being divided between the parties by the court. So here's an order, just so you can see it, of what this looks like. And again, you're not going to see this in court, this piece of paper, but the litigants you're observing may. So this is an order, and in this case, it's an order modifying a previous order. We'll get to that in a moment. But you can see in the box, basic payment, $355 weekly, if I'm reading that well enough. Bi-weekly, I can barely see. And then child care is, whatever that says, $288 bi-weekly. So that's just an example of, this is the result of some advocacy, either by the client, him or herself, or with an attorney. This is what the court is ordering. And one other note there, you see that the method on the right is SCU. You may hear this. That's the Support Collection Unit. It's a governmental agency that acts as the middleman between the person paying support and the person receiving support. So the non-custodial parent will send a check to this SCU address in Albany, and Albany will send it to Mom. Seems potentially inefficient. In some ways it can be, but especially for our clients who are domestic violence survivors and don't want a direct exchange with the other parent, this we always recommend. Also, SCU will keep an accounting of what's been paid. So we really do always recommend that the money go through SCU. SCU can also garnish wages if Dad works on the books at a company or something. And we'll talk about enforcement issues later. How am I doing on time? Okay, so sometimes you will see, and I just want to note this quickly, a deviation from child support. So you might see litigants arguing, or the court saying, okay, the Child Support Standards Act, the CSSA, says Dad's obligated to pay $560 a month. And then Mom will say, but my child has special needs, and there are extra expenses related to that, and I'm asking for more. So you may see an upward deviation, or sometimes, as I mentioned earlier, the court might see, boy, Dad is, we've got all the evidence in, it seems like, there's no more discovery to do, and Dad is really close to that poverty line. And so you might see a downward deviation to just make things fair for the parties. The court, as I said, is not looking to impoverish individuals, looking to make things right for children. And so there's a list in the statute, which I won't get into, of what factors, on the basis of what factors the court can deviate from child support. So even though you start with the formula, there is room for argument. And that's, again, where her justice really comes in. And just to set the stage for procedure, for what you may be seeing, here we are. We're in an initial order of child support, so it's the first time the parties are going for child support. They've never done this before. And you may be observing, and we'll show you on the calendar where this is described, and it's also something we're going to ask you for in the court monitoring tool. You'll see that some of these are first appearances or return date. That means that it is the first time that people are in court in front of a support magistrate. And the burden is on the petitioner, the person who filed the petition, to show that service was affected. So there are all kinds of rules around, which are constitutional requirements, due process requirements, for how the person being sued, just like in any civil case, has to have notice of that action against him or her. And let's say, Mom is going to say, well, he was served, here's an affidavit, a paper certifying that he was served on this date. It helps because remember how I said earlier, if Dad, let's say, defaults a few times and doesn't show up for a few of the court dates going forward, if Mom can prove that he was served and had notice and nevertheless didn't show up, she can ultimately get an order of child support based on the needs of the child. So service is important for that reason. Of course, it's important constitutionally, but for the ultimate outcome of the case, service is important. You might also see, if everyone's there, that the court says, where are your FDAs or financial disclosure affidavits, which I mentioned. You put your expenses, your income, your debts. The court is mandated to, and doesn't always, frankly, issue a temporary child support order. So in our experience, it sort of depends on the proof level in front of the court. The court really is supposed to, regardless of proof level, regardless of what documents have been provided, issue a temporary order on that first court appearance. So if the child, again, if the focus is on children, the court is supposed to respond to that by immediately at the first appearance issuing a temporary order of child support, which can always be changed down the road. That's what a temporary order is. But many times we do not see that. And then you will see, and we've had a number of law students do this court watching already in the fall with really fantastic results, incredibly valuable, and I think they've had a lot of fun, and I hope you do too. But we've been seeing a lot of adjournments, that's what you call them in family court, they're postponements, to obtain a lawyer, and for service reasons especially. We've been seeing a lot for service. Mom says at the return date, I wasn't able to get him served, I need more time. Or one of the parties shows up, since there's no right to an attorney, saying, I'm trying to find an attorney, I need more time. So you're going to hear these as reasons for postponements. And then what happens sort of next in the case, and there can be a number of these types of appearances, is compliance conferences. It's the court's way of checking in what's going on with discovery, the exchange of information, subpoenas that might be served to an employer, what's going on with all of that. And then again, you can see several of these type of appearances, and the court can keep making postponements. The truth of the matter is child support cases take a long time. So you will see multiple, you won't see, but I will tell you there are multiple appearances, like, I don't even know, 6 or more appearances in many child support cases. Unless everyone shows up on the first day with their W-2s, which it happens, but it's not common. And like any civil case, these cases can end either by the parties agreeing to the outcome or a court, after a hearing, issuing a decision. So I think settlement is more rare in family court child support cases. By the way, just for context, child support can be a part of a divorce case in Supreme Court, which is a different courthouse. And there you see a lot of agreements on child support as part of a total agreement, custody, child support, dividing assets. In family court, I think there are fewer settlements, but it's not impossible. And there are rules for what a stipulation or an agreement must provide or include. Calculating the formula, child support under the formula, any reasons for a deviation as I described from that, and how in the future the parties can change that child support. The court, since I mentioned earlier that child support goes until the age of 21, the family court has what's called continuing jurisdiction, which means it continues to have the power to address issues of child support until the child is 21. So let's say that, and we're going to get into this I think shortly, but let's say that one of the parents has a change in job and therefore income. That could be a basis to go back to court and seek a modification, and we'll talk about that shortly. Okay, so you might also see in terms of what kinds of appearances, a trial or a hearing. And these are, I don't know if any of you have taken trial advocacy or CPLR, but the procedure in family court, the rules of evidence govern, and the procedure is the same as pretty much any other case. I will tell you, it's kind of the Wild West in there, so you might not, if you're really like a procedure junkie, you might not exactly see rules being adhered to, but anyway, theoretically, the rules apply, and so trials look like they would in a car accident case or whatever, where the person suing goes first, in this case the petitioner, then the respondent, and there's direct and cross-exam. And the court frequently, the volume of cases in child support is huge. As I mentioned, 90,000 per year in New York City alone. So you see the courts kind of speeding things up sometimes and jumping in and asking parties. Of course, in particular, where people don't have lawyers. And I think you're going to see a lot of cases where people do not have lawyers, since there's no entitlement. All right. I mentioned the support collection unit, so I won't go through that again. Just to say that they do have enforcement powers if someone is not paying on an order, and I'll get to that in a moment. And then modification. So I just mentioned that if something changes in the family's life over time, you know, in our clients who come to us when the baby is 1 year old, you've got 20 more years when things can change, and they probably will. The court will address it. And so the petitioner, the custodial parent, can say, there's been a substantial change in circumstances, unforeseen to me, I lost my job, and so I need more support from the other parent. Or the reverse, right? I said earlier, the non-custodial can come in and say, I lost my job, I can't pay as much. There are some other bases. If 3 years have gone by, the court wants to refresh and keep that order current. There's a cost of living adjustment that sometimes the courts will apply to that order to increase it ever so slightly. And again, if I've lost my job, if there's a change in either party's income by 15% or more, that is a basis for modification. So you will see modifications, and when we look at a calendar, you will notice that the docket number ends with a letter. So it'll be like a bunch of numbers and then A, which means it's the first modification. Or a bunch of letters and then a C, which means it's the third modification. So many times people are going back and forth. I mean, again, parenthetically, in my view, there's a lack of public awareness about this, and so people sort of don't use the court when they should. They wait a while. They wait more than 3 years, or they wait for years beyond a change in their income and then finally go to the court, and things are messier then. So just to say that you may be seeing some modification cases. You may also see violation cases or enforcement cases. And these are cases where the order is not being paid. And by the way, you might see, and this happens a lot, a violation case, mom files a petition saying the order is not being paid. And dad responds with a modification, saying the reason I'm not paying is because my income has changed. So, our clients who are child support recipients, who are the beneficiaries of child support orders, have a right to seek enforcement of that order if it's not being paid. There's a sort of complicated thing, which maybe might be clear to you in one of these cases, which is mom comes in and says, there's an order from 2015, he had notice of the order, he participated in the case, and provided his proof of income at the time, and he hasn't paid me a dime since then. And his failure to pay is, as they call it, prima facie. It's sort of she meets her first burden, evidence that he is willfully, intentionally failing to pay that order, right? Because he had notice and he didn't pay, it must be willful. He then has the opportunity to respond and say, with a modification petition or not, and say, the reason I'm not paying is because I can't, and the reason I can't is because my employer downsized and I lost my job, or whatever that may be. So he can show inability to pay. And then it's the court's job to determine credibility there and figure out what's the right thing. Now, we're very interested in these cases because sort of the ongoing life cycle of our clients come to us for initial orders. What good is that if they're not getting the money later? And we also think that these cases kind of toil away in ways and with durations that they shouldn't. There's actually a statute, as I wrote on the screen, for expedited timeline, expedited resolution of these cases. The reason for that expedited timeline for this particular type of child support case is because the federal government gives New York State welfare money, and every other state, or most other states. And the welfare money is tied to the court resolving these quickly, because you know what? People who don't get child support go on welfare. So there's an interest in the state to resolve these cases quickly so that families are getting the money they need from each other rather than relying on the state. Very interesting political stuff. But anyway, so these cases are supposed to be done quickly. So we have a couple of questions in the tool that go to this issue. The other things you will hear here are that the courts are doing what is called a post-dispositional review. Now, this is my advocate's hat. This is made up. It is not provided in the Family Court Act or in any other statute. So it is this period of time that the court, and you'll see it on the calendars, and you'll possibly hear about it. It's what it looks like is, again, we're in a stage of a family's life where there's already an order of child support based on everyone's income. It hasn't been paid, now we're here. And this post-dispositional review is this seemingly endless period of time where the court is directing the non-custodial parent to go get a job and bring back proof of that. What's problematic is that there are enforcement remedies under the law that are not being taken advantage. And those are, on the screen, the court shall enter a money judgment. A money judgment is a piece of paper that says there's this amount of money in arrears. You might hear that term. Arrears are unpaid past due support. The beauty of a money judgment is that when the court issues that, 9% interest, which is also statutory, starts accruing. Again, thinking about how our clients get that money is another matter altogether, especially where in our population that we serve, it's not typical that the other parent is sitting on $1 million house or some other asset that can be seized, but theoretically, one can take a money judgment and you're a creditor of dad or the non-custodial parent. The court may suspend licenses, deduct income from wages, and ultimately the court can threaten or even issue commitment to jail for failure to pay child support if it's been willful, if the court has found that it was intentional. You may hear a term in this context which is called a purge amount. That is an amount of money that is up to the court's discretion. Let's say dad, owes $10,000 in child support arrears, past due support. The court may say, all right, I'm setting this down for another appearance in 6 weeks. Pay $2,000 as a purge amount, or else at that next court appearance, I'm sentencing you to jail. It's an up to 6-month jail commitment. So that purge amount is basically dad's way to get rid of that contempt of court for violating a court order and failing to pay. You may see that. If that happens, the magistrate, the family court judge has to review the magistrate's decision. Again, you're going to be watching magistrates, so just wanted you to have a context there. Let's see. I think that's it on substance. I know it's a lot to go through, but I think this is going to be useful. Jackie's going to talk to you about the tool and the calendars, and I think it's going to loop back to some of the concepts in a way that feels real because you're going to see it on the paper. Good?
Yeah,
Okay.
great. I'll grab the.
Okay, yeah.
Thanks.
Did you do my part?
We have, but you can,
you can
add some
add
at the end.
Please.
It's okay, I'm just asking.
Yeah.
All right, so this is now the part at which we teach you how to do your job. So if you want to, I know you've got the slides in front of you already, but if you want to get out this single piece of paper, which is the survey tool itself. Now, at the end of today, we'll ask you for your availability. There's a piece of paper just there for you. You'll tell us when you're free. We will, especially for the first time that you go, we'll look at your availability, we'll look at all the court calendars, and we'll find a magistrate sitting who's going to be doing the right type of cases, and hopefully a bit of a mix of interesting cases for you to go. So we'll schedule you a time to go and a magistrate to go and see. You will turn up at the court on the day. Depending on the court that you go to, you might wait in the queue for quite a while, allow some time for that. That's, for me, at least part of the experience of family court is when you get there and there's a queue of 100 people in front of you waiting for the metal detector. You'll then pass through, hopefully you haven't brought any weapons or anything, and you will find your courtroom. That's, I said, the queues are the first challenge. Finding the courtroom can be the second challenge. There's not really any rhyme or reason to where the parts are in the court. Like part 25 might be on level 8 and part 23 might be on level 6. Look at the maps, you'll figure it out, you're all very smart, and any issues that you face, litigants will face 10 times over, so please tell us about them as you're writing up your reports. You'll then find the waiting area, you'll find your courtroom, and you can enter the courtroom straight away. There's no need to wait. Some people are more comfortable just waiting until one case is finished and walking in at the beginning of the next one. You can introduce yourself to the court officer if you choose. There's no need for you to do so. Again, some people feel more comfortable just letting someone know that they're there. You can introduce yourself as a law student who's doing his observations with her justice. You might even find some magistrates are really interested that someone's there. Often these courtrooms are tiny and you might be quite obvious. I've done some observations literally standing at the back of a courtroom with my little form. And in between cases, a magistrate might just ask you, who you are, why you're there. In my experience, I've been really interested to have someone who wanted to come and see what their courtroom is like and was interested in improvement. So don't be shy about that. No one's there to interrogate you.
And they know that we're doing this project. This
there's
included
nothing
with the course, right? And we've had students do this in the fall, so everyone knows this is happening.
Yeah. So you'll sit, or if you're unlucky, stand at the back of the courtroom without disturbing anyone, obviously, filling out your forms. We recommend that you fill them out in paper in the courtroom because the Wi-Fi is either non-existent or bad often. Some magistrates can be a bit uncomfortable with someone's typing at the back as well. So we say fill them out in paper. When you go home that night, straight away, put them into the system online for us while it's fresh in your memories. So when we schedule you to a courtroom, we'll send you the court calendar. And this is what it looks like. And not only will that help you know where you're going and what you're doing, but it's incredibly helpful for all of the next questions. So, as you'll see at your survey at the beginning, we're asking you obviously for your name, but also for the magistrate's surname, the county that you're in, the date, you'll have the correct spelling, etc. from the court calendar. We also ask you for the case scheduled time and then the actual start time and end time. And as you look at this calendar, you'll see that the second column is time. That is where you'll find out what time the case was scheduled to begin. These are not entirely reliable. Sometimes you'll see here on this particular calendar, there are 4 cases scheduled to start at 9 a.m. The first one at 9 a.m., you might not be exactly sure which one it is. I'll continue on and we'll see. You'll probably be pretty good at working out which it is of the 4. But it's quite common for lots of cases to be scheduled for the same time. Some magistrates just schedule 30 cases for 9 a.m. People show up and they wait. They wait for literally hours. We're very interested in that. That's why we're asking you what time the case really starts. Because when parents are coming into court for child support, lots of these are single mums or single dads who have work themselves to be paying for their child's needs and who are taking a day off, who may not be getting paid for that day, who are risking their own employment. And especially when you combine that with what we'll talk about later with adjournments, we're really concerned about people who are spending a whole morning or a whole day at court again and again and again for little benefit. So just be careful about actually recording those. And I think it's easy to forget also when you're in the courtroom as you're watching and there's a bit of drama, but make sure you're keeping track of those times. So the first substantive question is the appearance type. Again, the court calendar is really helpful for that because you'll see that there's a column called purpose. And if you look down that column, these will look familiar. There's a compliance conference, there's 2 trials, and there's 2 post-dispositional reviews scheduled for that day. Later on, there's a willfulness determination. With that court calendar, you'll find it really easy to know what's going on. And if things are keeping to schedule, then filling this out will be a breeze. If things are not keeping to schedule, you'll be using your own observation and insight a little more. But it's very helpful.
How will you know who the parties are, who you're watching on the list? They call the case?
They call the case. Different court officers do different things. So some court officers will call out the actual docket number. I usually jot that down because I find it helpful. You don't actually need to match up the cases exactly with this calendar. And you don't always know exactly what's happened either. So sometimes a case might have been listed, might not even go ahead. Someone's told the court officer in advance. It's just never called. So to the extent that you can match it up, it will help you cross-check with the calendar. But you don't need to, because as you're sitting there, you will know whether you're in a trial or in a first return because of what is happening. So we say that the court calendar is a useful tool, but it's not essential. Looking still at this court calendar, you'll see that one of the areas that I've circled there is this CSMS number. The reason why we teach you about that is that some of them start with the letter N and others start with PA. PA is a public assistance case. If you see one of those, you don't actually need to take notes about it because we're not tracking data about public assistance cases. If you are not sure, track it anyway. We can work it out from our end at the end. But if you see that PA, you can take a 5 or 10 minute break while that case is happening. To the left, you can see the docket number. Rachel was mentioning before that sometimes you'll be able to work out from that whether a case is a paternity case or a regular child support case. So all those start with the letter F. That's all just regular child support cases, but a P would be paternity. The other thing that Rachel mentioned before was you can see these letters at the very end of that docket number. There's a few D's and E's, and I think there's an F and an A. As Rachel mentioned earlier, that shows you whether how how far into the case's life history you are. So an A will be the first time parties have come back to court, and F, there's been a lot of applications in the life of this family. Sometimes, in fact, there'll be 2 cases for the same family. So I think you can see the second and third cases here. It's an A and a B with the same docket number. That's probably, like Rachel mentioned before, one parent is asking for enforcement of the order, and the other parent has a cross petition asking for, say, a downwards modification. Those 2 cases are heard together. It's the same family. It's all the same issues. So I think that it's complicated looking at this for the first time. Sitting in a court with it next to you, I think it all falls into place. And you should always, of course, feel free to contact us if it's unclear. But it's a helpful tool. And as you go on continuing to volunteer, you'll probably find that you can just look up calendars yourself and you'll have a bit of a sense of what will be interesting and worth watching.
Can I just add here?
Yeah.
Too, sometimes on the door, the cases are hand numbered by the clerk, and they'll just call out calling number 5 on the calendar.
Yeah.
Or calling 5, 6, and 7 on the calendar, and that's one family with 3 applications. So you might just, if your printout doesn't have numbers, see if the one on the wall does, because you might just hear these cases referenced by a number on a list.
Yeah. Yeah. But you might look at your calendar and see that there's one case listed for 10:30 and it's 10:30. So it's, you can match it up pretty easily and cross-check that what you think is happening is exactly what was scheduled. Okay, so the next question number 2, is about case type. So these are the 4 types of cases that Rachel talked us through earlier. So are we looking at an initial child support determination? That's the first time that the parents have come to court seeking a child support order. Is it a modification? Someone's coming back and asking for more or for less. Is it an enforcement case? Someone's not paying the order. Or is it a paternity case? And it's the very first step, establishing which parent should even be paying child support in the first place. This case type is not listed on the calendar anywhere, but when you're in court and listening to what the parties are saying, it should be quite clear. The magistrate will be asking for the first time to see what people are earning and talking about a temporary order while we're getting more information. Or they'll be saying, why haven't you been paying? I can see from the records here that there's a $10,000 debt. So you, of course, mark which of those it is. It might be more than one. On the form, you're able to tick multiple, so you might tick that it's both a modification and an enforcement case. And you'll see from the form, sometimes this is just hard to tell. Tick unable to tell if you can't tell, and then continue with the rest of the form. We're still very interested in all your observations about how parties are being treated, what their experience of accessing justice is like, even if you're not clear on exactly the type of case. The next question is about the posture of the proceeding. And there's 3 options there. Was it contested? Was there a default, or did it settle? Contested case, both parties have turned up to court and they have different ideas about what the court should be doing in their case. A default means that one party has not shown up. And settled, you usually see both parties turn up, but they'll have agreed on the order that the court should make. These settled cases, as Rachel mentioned, are pretty rare in family court, but I've seen some really unusual ones, like 2 parents coming in saying, we'd like to end this order of support entirely. The child is actually 20 years old. She's now independent. We know that the order has another year to run on it, but we really don't need it. So we've seen, I think there's been 4 or 5 of those across the cases we've observed already. So that's an interesting case. Mark that it's been settled. We'll be interested to see your observations about it.
May I just I'm not sure. Did you show people this?
We'll get to that at the end.
Okay,
Yeah.
I just want to bring it up now for
Yeah.
me in the training. Everything that is coming out of Jackie's mouth is actually in this. So, each question here is described in further detail here. So don't worry that you're like, what the heck is going on here? Because everything is in here, question by question by question. So that really gives you this roadmap to, while you're sitting there, go, oh, okay, that's what this means. Okay, I just wanted to bring that up now
Yeah,
because
thanks.
there's a lot of information being put forward. Okay.
Yeah, absolutely. Okay. So this front page is very objective information, right? What type of case are we looking at? What's the magistrate's name? Is the petitioner the mother or the father? Do they have a lawyer or not? They're really yes/no questions. And then if you turn over the page, we have a series of much more subjective questions. And I mean, obviously, we're seeking volunteers who are law students because we think that you'll be brilliant at this. You'll understand the law. You'll be able to identify the type of case accurately. But also because we think that your observations and your opinions about the experience of justice that all these parties are receiving will be insightful and accurate as well. So we've got this series of questions where your opinions really matter. And I think really to tie in what Denise was saying, we've provided information about the types of issues that we consider when we're answering these questions, and some real guides either way. So, for instance, if you look at the second question, did the magistrate inform the parties of their right to seek legal advice? Obviously there's different ways that a magistrate could do this. Some of them might be very detailed in explaining what you can do, resources you might want to look to. Others it might be more perfunctory, and others really might not even mention it. Or something that we've noticed and been concerned by is some magistrates don't inform parties themselves of the right for an adjournment to seek counsel, but a court officer says it very quickly at the beginning of the case, and then the case continues on. We want you to really think about whether you as a party sitting in that room would have known that you could have said, I want to stop the case now to seek a lawyer. And we're asking your judgment on that question. And we hope that you'll see that happen every time. That should be very, very common. But if you have concerns that either it didn't happen at all, or that the way that it happened was so brief or so rushed or so confusing, that you might want to tick the no for an instance like that. Another example of a real opinion-based question is something like, did the parties have enough time to explain the issues to the magistrate? These cases can be short but not rushed. Sometimes it's a very minor issue. All that's happening is the case is being set down for another hearing in the future. The case might go for 2 minutes, but the parties had enough time. That's all that had to happen. You might see a case that goes for half an hour and you didn't think the parties had enough time. They were still sort of asking questions, they're being ushered out of the room. Someone goes to ask a question and then the case has moved on and they look confused. You will know, I think, when you're in that room, whether the people had enough time or not. And just use your best judgment to answer that question. There's no right or wrong answer to that. Obviously, it's your opinion. You can also answer not applicable for questions. So a good example might be when a technical legal term arose, did the magistrate explain its meaning to the parties? You might think that not a single technical legal term really came up because the case was so quick. You don't have to tick yes or no. You can just tick not applicable for that. We think that technical legal terms come up pretty often. So I'd expect that you usually would be able to answer yes or no. To us, a lot of those terms become very natural, but a party might not really know what an adjournment means, or they might not know what it means their case is being dismissed, whether that's really the final step or if they have to wait for something else to happen. Again, you'll use your judgment, and we've provided a lot more guidance about what that might look like and examples where we think it sort of swings one way or the other. And then finally, the largest box down the bottom is where we ask you to record the outcome of the case. So this is an example of a time when you have to listen carefully. The magistrate will always say their order at the end. That order might simply be that the hearing is adjourned to a particular date, but nonetheless there'll be an order or the case will be dismissed. That dismissal is still an order. Hopefully you see a lot of cases where a support order itself is entered, so it might be a temporary order until the next hearing occurs, or it could be a final order of support and then you'll know what the actual order was. It might be $300 a week. This is another area where you might be ticking multiple boxes. It's really common that there'll be a temporary support order entered and there'll be an adjournment for another month. And the non-custodial parent will be asked to participate in a job training program. In that case, you'd tick all three things. Now, you'll see that there's also a space to enter the date that the hearing was adjourned to. If you can catch this, it's very helpful information for us because, as we've spoken about a little already, a lot of cases are adjourned and often they're adjourned for a substantial period of time. So someone might come to court really urgently seeking a child support order, and the case might be adjourned off for 3 months. 3 months is a long time without child support. Or you might have someone, and I've watched this often in court, where maybe the father has turned up, he brought some evidence, it's not enough, the magistrate can't make a decision yet, they'll adjourn the case, and mum will say, I've been here 3 times already, I brought this case 6 months ago and I haven't had any support yet. So that's the kind of note that we would love you to make in your other comments. We want to know when people are not receiving the justice that they're coming to the court asking for. And we also want to keep track of how long cases are being adjourned for. And I mean, the beauty of this project is that we can then be really specific when we report back to the courts. So we can say, you know, we recorded all the types of cases, and we know that in willfulness cases, you're actually adjourning for a month, and in just regular child support cases, you only adjourn for 2 weeks. Well, you know, what's happening in the court here? Why is there this difference? Why are some cases being treated as more urgent than others? We'll have a lot of data to be able to use to really encourage the court to be applying justice equally and fairly. And then, of course, as I mentioned, we're asking you for other comments. We find it really helpful when you give us a narrative of what happened in the case. And we found that with our last set of volunteers, a lot of people were doing that anyway. They were just taking general notes of what's happening. And it's so helpful for us when we write our report. And I mean, Denise knows more about this than the rest of us, but when you look at the reports that she's provided previously, you often see beautiful anecdotes that really give meaning to the statistics. So people might say, you know, 30% of cases had an interpreter, but here we have some anecdotes about where an interpreter was really needed and wasn't provided, and here we have one about when a magistrate was really alive to issues, identified them straight away, got an interpreter in, and the case proceeded. These are provide the court with guidance, what we think is like fabulous and sometimes like quite problematic behaviour, which sits behind those stats. So that's the form. Take some time to familiarise yourself with it. Read through the whole guide. I think you'll find it very helpful. I hope that you will, and also comforting before you go into court and start doing this. You can always call us. I've had volunteers call me from court just to check in with the way that they're doing the form, or send an email and saying, in my opinion, these types of cases all needed a lawyer. Is that okay? Feel free to do all of that. We want to make sure that we're very available to you, and we will be. I'll say from my own personal experience that watching these cases is fascinating. I've done a lot of observations with volunteers, and I did some when we were piloting the project in the first place. And for me, it made what sometimes seems a bit of a dry and abstract issue like child support suddenly extremely real. People aren't in court for fun. People aren't in court for $10, $15. They're there, really to support their children and to allow themselves the ability to work and pursue their own lives and dreams. I've seen cases where people have been in court for years and are owed $100,000. I've seen cases that are just started that day with a paternity action. I think you'll find it a really rich and rewarding experience, and we're thrilled that you're volunteering with us. So I might, at this point, pass over to Denise. We did a little introduction to the purpose of court monitoring.
Okay.
If you want to add to that, that would be fabulous.
Okay, good.
Do you want to sit here so you're on the video?
Nah, that's cool. So first I was going to say, since of the time being short, maybe if people have questions, then I could speak, but I'll just, either way. I mean, we can do it either way.
I think we've got time. Yeah.
Okay. Well, since it was already brought up, court monitoring has been around for decades. And as I just want to reemphasize those 3 purposes of court monitoring. One is just for the public themselves to be able to go in to the court to see what's happening, because the judicial branch is the least watched branch of all 3 branches. And I would like to add to that now the judicial branch is under attack. I'm being honest and real, and not conspiratorial nor false. I just went to a convening in Chicago of fair courts groups from across the country, and what's going on in state courts in many states, North Carolina, Florida, Kansas, happened in Iowa years ago. There's a lot of attack from the legislative branch or the executive branch or really money, business, dark money, that's kind of trying to diminish the equal power of the judicial branch of government. So watching it on any level is essential for people, okay? It's really important now. There are watch programs on criminal justice issues. There are watch programs on gun issues. There's watch programs on domestic violence. There's watch on whether bail is being right. There's watch on drunk driving. There's watch programs on all these issues. So what you're doing by going is really important. And then, of course, so that's kind of what I wanted to stress more this time than usual, that piece. In terms of accountability, that's very important for people to be there. So a judge sees somebody's there, or a magistrate sees somebody there. I can't underemphasize how much that matters. You know, even if they're going to act better when you're there, it's still okay that you're there, right? You know, they'll improve what they're doing. The other thing is, this is not, and maybe this is raised not, court monitoring is not a gotcha thing. It's not like, you also want to note when it's good. You also want to note when they were really appropriate, because first of all, that's important to the system. You're never going to be a good advocate if what you're doing is just, you know, poking people in the eye. You have to compliment them. And not everyone is bad. And so there has to be a recognition of the quality of their work and how they're doing their work. And then the other part of court monitoring is this potential for advocacy, which they spoke about. So that goes on all over. You know, that's just one of the three parts. And that's a very critical part. And I will say that what Modern Courts has done is monitoring with lay volunteers. So you can consider yourselves law students and you have a capacity to understand all this, but if this is a new proceeding that you're going to see, you really still are, maybe you have the knowledge that you were trained on here, or some of it, because, you know, oh my God, how can you remember everything? But you're like that litigant. And you can't be like, oh, I'm a lawyer. You know, you're like that litigant. And you're like, you know, I don't understand. And I have to say this very strongly. If you don't understand, it's not because you're stupid. It's because you don't understand, and something's wrong with how that magistrate is presenting that case. That's from my opinion. And I think that's really hard for attorneys, because we think we should know things before we know them, right? We think that if we don't know something, then, oh, maybe we didn't learn that, and maybe I should learn that. No, you're in there. If you don't know it, if you don't understand what's happening, that's because it's not being understood. The fact that a court officer is telling people about the counsel, you know, I'm sorry, that's not appropriate. You know, I mean, I had that on. I had to represent my son down at the beach and a bunch of his friends, and the court officer was the one telling us what the law is. I was like, really? You know, that's not appropriate. So that's a remark you'd want to make. The other thing here on one question I just want to bring up is, in your opinion, would unrepresented parties have benefited from representative counsel? You may answer yes or no. I would say also say how. You know, I would just say that to say how. So I think what you're doing is really, really important. And I also think what you're doing is great for your own education as lawyers, because I don't know what, when I first started out, and I practiced for a long time, you know, I didn't even know where the address was, right? Or what room to go into. And that's kind of a very scary anxiety thing, because you want to look like you know what you're doing, but this kind of gives you that leg up to start getting that feeling of what it is to be in the courthouse without actually having the responsibility of representing anybody. So it's kind of a really good program. I don't know if you brought that up or not.
That's great.
So
That's true.
that's all I'll say. So thank you, because it's big now and important to do this work.
Do you have questions? Okay.
Yeah, well, we'll stick around for a few minutes anyway if you do have questions. I think we mentioned we've already had a group of volunteers go through this process. A lot of them are still going on. So you are part of a bigger group, but that bigger group really is their insights that will be driving this report. So we're so grateful to you.
Thank you so much.
Yeah, thank you.
I'm going to shut this off.